I have Ms. Call present with us, Ms. Keefe, and do I have Mr. Alton? Yes, I see.
Yeah, I'm here.
Very
I can
good.
barely hear you for some reason.
Okay. Good idea to leave your screen. So it's okay to mute your video. Sometimes the video takes up a lot of the bandwidth of your connection. So if you want to leave the audio on and mute your video, sometimes that helps folks with their connection on their end. Okay. Today was the day set aside. Mr. Alton, I'm just going to mute you just so we don't get any feedback. Today is the day set aside to have the final Guardian ad litem review hearing. Looks like the judge ordered a couple additional things at one of the last hearings, and we're still waiting on those to be completed so that the Guardian ad litem can complete her work. I did receive a request from the Guardian ad litem to extend time for her final report. That seems reasonable to me. I'll turn to you first, Mr. Alton. Do you have any objection to the Guardian ad litem's request to reset the date out that gave her additional time to complete her report?
No, I don't.
Okay, very good. And Ms. Keefe, how about you?
No, I don't.
Okay, very good. And Ms. Call, how far out are you asking for?
Good morning, Your Honor. I am requesting that we go to Thursday, August 3rd, in part because Ms. Keefe, we're waiting on a UA result, and then also Mr. Alton has gotten kiddo into counseling, and so I'd really love to see an assessment and some feedback from a mental health professional before I make recommendations in the report. So I'm hoping that offering a few more weeks, going out 3 weeks, may give us enough to achieve those things.
Okay. And Mr. Alton, how many sessions has the child had with the counselor?
He's just been to one. Yesterday was his first one, and then he has another one on the 26th.
Okay, so with that information, I think what I'm going to do is actually push it up just a little bit further, give the child a chance to have maybe a few sessions on board, and also a chance for all the other reports to come back. I don't want the reports to come back on Wednesday and the Guardian ad litem's reports due Thursday. And so my thought is I'm going to push this out to the end of the summer. And so does August 31st work for you, Ms. Call?
Yes, it does.
All right, very good. How about for you, Mr. Alton?
Yeah, that works.
All right, and you, Ms. Keefe?
Yep, that's fine.
Okay, very good. So we're going to have a review hearing on August 31st to make sure that the Guardian ad litem report is in and everybody's had a chance to receive that on August 31st.
Okay.
Right. And then Ms. Call, I did receive your motion. You didn't sign it. So any objection to me writing approved via Zoom?
No, that's just fine. Thank you, Your Honor. I apologize.
All right, very good.
There were several filings yesterday.
Very good. I understand. So with that, we'll set the matter over to the 31st. We'll see everyone back here at that date and time. Anything as far as further reports and things that you're doing for the Guardian ad litem, just make sure that you're pushing to get those done so that they get to her so that she can finish and finalize her report.
Okay.
All right. Thanks very much, everyone. We'll see you back here on the 31st.
Thank you.
Yes, Your Honor.
All right. So in this matter, I have a conflict. And what that means is just either myself or my firm at some point represented or had some sort of representative capacity with one of the parties. And my records reflect representations potentially on both sides, depending on the firm that I've been with in the past. So given that, I shouldn't make decisions on the case. It wouldn't be fair if I've represented somebody or somebody my firm did in the past. I don't think people would feel confident in me being unbiased. And so when that happens, we set the matter over. So what I'm going to do is I'm going to set the matter over just 1 week. And then that way a different judicial officer should be here next week and you can get your matter heard.
Okay, no worries. No problem at all.
Very good. See you next week.
All right, thank you.
While we wait, can I discuss something with you?
No, we have to wait for that person to join. Because we're doing this via Zoom, it's a little bit different than we would have if we were not via Zoom.
Okay.
All right. And do I have?
I'm here.
Very good. I'm glad you were able to join. All right. So I am calling the Ash and Ash matter. This is on for a review hearing regarding evaluations. We were last here, looks like back in June. And what the court's expectation was that there would be proof of clean UAs filed. The court ordered a hair follicle test at that point, and then expected to see copies of the substance use treatment and any treatment with CORE being filed with the court. Did anyone file any of those types of documents?
So I have this document right here that's I just tried to submit this morning. Unfortunately, this is front and back and colored. I'm not aware that this is not court approved, but this has all of my records in it, all the core UAs, everything else. I was just unaware that it needed to be not front and back and colored. But I have 2 copies of this, one for you guys and one for Miss Ash. And then so if she will willing to take one of these, I can get you guys the proper copy of it not being front and back. Unfortunately, this cost me a little bit of money to get these records. So I get paid next Friday, and I can have a hair nail follicle test paid for at that point. I also have the anger management evaluation lady. It's about a month out, but it costs another $550. Her name is Olivia Lovely, and so I am just waiting, a couple more paydays, but I should have this resolved, on my end within a month. Things are just kind of expensive, but I do have these records for you guys, so I can at least get Miss Ash her copy. So that'll at least, and then I will just have to go print you guys off the appropriate copies. I already bought a seal, like a covered seal.
Okay, perfect.
So unfortunately, she just informed me this morning that you guys just don't accept that paperwork like that. So I will go get the approved stuff and turn it in, hopefully by the end of this week or sometime next week.
Okay, perfect. And the reason we can't have it front and back is it all gets scanned into a computer, and if it's front and back, I'd only get half of it because the back half wouldn't scan.
Yeah, absolutely.
So that's why we want to make sure we get the whole record and not sort of every other page.
And this is 271 pages. So
does it have your substance use information in there as well?
Absolutely. So like these ones right here, I don't know if you can see that, but I have probably like 25 of these. These are clean UAs. This has my SUD evaluation and the date it was given. This has, I think, everything you guys need. If not, I can go get more paperwork if this isn't everything. I went back from when I started at court, and I've been through a couple counselors. So I got records from each individual. My peer counselor that I meet with every Thursday, his records are in here. So pretty much everything.
Okay, very good. Do you, Miss Ash, is there an address you would like him to send your copy?
He can send it to my address. He has my address.
Okay, so Mr. Ash, what I'm going to have you do is, it sounds like you have the cover sheet and understand that you need to have it on single-sided sheets of paper. So you're going to make that copy and file with the court. And then you can send, if Mrs. Ash's copy is double-sided, I'm fine with that. You need to mail her copy to her address. So she doesn't pick it up from you. Your job is to mail it to her.
Okay.
And then sounds like you needed a little bit more time to get the hair follicle done. And that's understandable. I do recognize that those can be a little bit pricey. So if we were to look about a month out, that would take us to, I can either go a month or a month and a half out. What do you think is going to give you the best amount of time to complete everything you need to do?
I can pay for the hair and nail follicle test next Friday. That's not a problem.
Okay.
And then it's just, saving, like $250 on a check, and then the next check also saving $250. So can we go for a month and a half? And that way, I can have like, a good 3 checks in there, and I can at least have by the next time at least have them, the anger management assessment paid for.
Very good. Okay. So what I'm going to do is I'm going to set the matter out to August 31st. Does that work for you, Ms. Ash, date-wise?
What day of the week is that? Oh, Thursday. Never mind.
Thursday.
That'll be fine.
Okay, very good. So I'm going to set the matter out to August 31st. Do, sir, get the paperwork that you have in hand, get that filed as soon as possible. I understand the hair follicle and some of those things may come in later. You can make a photocopy of that sealed sheet and reuse it because you'll also want to seal your hair follicle results and any other evaluations that you get should be sealed as well. So you can just photocopy that sealed sheet and reuse it a couple times. And then by putting it out to August 31st, that'll give us a little bit more time for you to complete those things and for all those to make it into the court file.
Absolutely.
Okay, sounds good. Any questions from you, Ms. Ash?
So after he's completed all of his basically prerequisites to re-engage with Jordan, are we going to be looking at reunification counseling? Like, how's this going to go? Because my concern is all the hard work that we've done with Jordan to get him to where he is right now is going to fall apart, because this whole situation comes with a lot of big feelings for all of us.
Yeah, absolutely. These are a lot of big feelings and a lot of and potentially some big changes for a young person. What you can do between now and the 31st is to write a declaration and submit that to the court about your concerns and what the child's needs are. I can't tell you exactly what the court's going to do because it would really depend on the records that I receive, both from you at that time as well as Mr. Ash. I can't. I don't know what those records say as far as his materials with CORE and his work on in treatment. And those will likely dictate significantly how the court moves forward. So I encourage you, Mr. Ash, to file all of your materials that we've talked about, and then Ms. Ash, for you to file a declaration that just outlines for the court in advance sort of your concerns and your suggestions on how to move forward.
And will Mr. Ash need a copy of that? Can I just mail it to him as well?
Yes, you can just mail it to him as well. Do you have an address for him?
If it is the same as the one on the original documents he served me, then yes.
Okay. Mr. Ash, is that address changed or is it the same?
It's 15 something.
It's 15.
Okay.
Very good. So yes, you just need to mail it and then make sure that the court gets the original copy from the clerk. So I always say you want to make at least one original and 2 copies. So you have a total of 3. One, the original goes to the court and the clerks, and that gets scanned in for the judge. You have a copy to keep for yourself and a copy to mail out so that everybody can look at the same piece of paper when we come to the next hearing.
Okay.
And then you want to make sure you submit that at least 2 weeks in advance of the hearing. That gives enough time for you to drop that off, it to be logged and stamped and scanned into my system, and then be able to be spooled into my version of the system prior to the hearing.
Okay, that sounds good.
All right, very good. All right, any questions from you, Mr. Ash? Okay, very good. Thank you both for being here. We will see you next on August 31st.
It's Gina Canoni.
All right, ma'am. Thank you for appearing. I did see that you're the petitioner on this matter. Is that right?
Correct.
All right, very good. And it looks like the mother was served and signed a consent. Is that correct?
Correct.
All right. And so at this point, what we're still looking for is having the father served. Are you working on that?
I am. We've been through, I just sent a certified, another certified copy over there to the prison. And what they said was they will not sign the service paper, but they will email me a copy of the ledger that the prison keeps for serving mail that is certified. And that he said that will suffice in court. I also tried to get the sheriff's department to serve at the prison, and they will not.
Okay. So looks like since we were here last, mother's been served and signed a consent. We're still working on service of the father. Sounds like he's in prison. And so sounds like that's somewhat in process. How far out are you requesting that we give you time to get that information from the prison back?
Are you talking to me or Miss Farr?
To you, ma'am, because it sounds like you're the one who they're going to email you.
Okay, I thought you were talking to Miss Farr. 2 weeks.
Okay.
Just to make sure that I get that email back, or if I have to, I've been dealing with the administration at the prison, and I got more help when I went to the mailroom.
Okay.
So there you go.
So what I'm going to do then, that seems reasonable. You can also ask the court for permission to serve by mail. You would have to do that via a motion. So that's not before me today, but that is something that is available. So I'm going to set this matter over to July 27th. I'll sign an extension on the current orders to that date. Give you a little bit more time. Remember that anything you receive by email, I can't see your email. So you need to print that, file a copy with the court so the court can review that.
Correct. Okay.
All right. And then make sure you send a copy to Ms. Farr as well.
Yes, I will.
All right. Very good. Anything further on this matter, Ms. Farr?
The only thing we're waiting for is the proof of service. Everything else is in order. So.
All right. Very good. And anything further from you, ma'am, on this matter?
Now, do I have to have, my question is, do I have to have the actual proof of service letter for Haley and well, I can't get one for the dad, but I have to have a proof of service letter also, as well as the letter that she signed?
I'll help you with that, Gina. So we'll schedule a phone call and I'll walk you through that.
Okay. All right.
All right, perfect. We'll see you back here in 2 weeks. And just before we end that, Ms. Powers, anything from you on this matter?
Thank you. I know we're not dealing with it today, but I do want to make sure the parties know that the state has gotten involved and is requesting child support. We did send out proposed worksheets in order, and so we'll deal with that before it gets finalized.
So everyone, it's just important to remember that Ms. Powers represents the state of Washington, and so she is a party to the action. That just means that she's entitled to service as well. So anytime you're dropping something off for the court to review, you want to make sure that Ms. Farr gets a copy and Ms. Powers gets a copy, so that everyone is looking at the same document at the same time when we come to court.
Okay, does Ms. Powers have a email address?
I'll get that information to you too, Gina, when we talk.
Okay.
I'll explain the
thank
whole process to you.
Okay, thank you.
I can also put it in the chat for you as well.
25508. Do I have parties appearing on that matter?
Yes, Your Honor.
All right. Thank you, sir. Anyone else appearing on that matter?
Yes.
All right.
I'm here too.
All right. I see you there, ma'am. Thank you. Okay. So there was a motion filed to end the guardianship, and let me pull up that. And so, all right, and I see you there, Mr. Peters. And so, Mr. Peters, I'll let you go first.
Okay, well, I believe we filed the motion for emergency guardianship to transfer that guardianship from my sister back to me. And then all the other paperwork that needs to be filed for the permanent guardianship is done and will be submitted today.
And Ms. Farr, are you working on that matter as well?
Well, I haven't been appointed to it, but I would assume that I would be. So I will need an order appointing guardian ad litem on that one. So the situation is that we were just waiting for Mr. Peters to get his documents filed. The Judge Bassett put on hold signing the immediate order appointing him until today. So we need to get that order signed to get him in place, as well as get the previous case terminated where Ms. Cutbreath was appointed as the guardian.
Okay. And so I will go ahead and appoint you, Ms. Farr, in this matter. That makes sense. And it seems like you're already facilitating some efforts between getting the child transferred. Where's the child currently residing?
He currently resides with me.
Okay. And your request is for him to be placed with Mr. Peters?
Yes.
Okay. And Mr. Peters, it sounds like you have a lot of the paperwork ready. It just hasn't been filed yet.
It's all ready to go. Yeah,
okay.
We're going to come down today and get it filed.
Okay.
Your Honor, he filed the emergency petition.
I did do that.
He just hasn't filed the permanent petition. And the reason I was guiding him to get that done is so he only had to serve mom once with both. Yeah.
Seems reasonable. Okay. So what the court's going to do at this point, and sir, did you propose a order? No. Okay. So what I need is an order that would actually transfer the child from Ms. Cutbirth to you, sir. And I don't have that. And so what I'm going to do is I'm going to set the matter over, but I don't want it to go out far. So I'm going to set the matter over just 1 week so that you can file the paperwork that you said is all ready to go. And 2, so you can propose an order placing you with the child. And then that way we're not sort of transferring the child when one person technically has guardianship and then but is living with you. We kind of end up in this weird in-between land that isn't very effective for the child or either of you.
Sure. So
I'm going to have you get that paperwork filed, propose an order to the court that places the child with you in the immediate guardianship case. And I'm just going to set it over 1 week. So that gives you a very short timeline to get that all done. So the paperwork you said is ready to go, better be, because it basically does need to be filed today. It takes a little bit of time after you file for your paperwork to actually, it gets scanned and then put into my system so I can see it.
Sure.
But I think that's the most responsible thing we can do to make sure that the child's transfer is as smooth as possible.
Okay.
Your Honor, you should have the immediate order there in front of you. It was presented to the court with the emergency filing, and Judge Bassett said she pulled it from ex parte to hold on to it.
Judge Bassett signed that order saying that it was going to be dealt with today. So that order has already been scanned and signed. Got it.
Okay, so he just needs to present another immediate order that can be signed ex parte. Could we do it ex parte instead of another hearing?
I'm fine with doing it ex parte. So if you can submit that order, it can be signed ex parte. It should just reference the fact, make sure it references the fact that the child's being transferred to Mr. Peters. Sounds like that's going to be cooperative, so I don't mind it not having real specifics about that. But that the case with Ms. Cutbirth then is being dismissed by agreement.
Okay, I'll help him with that. And they've been sharing custody of the child, basically. When I say custody, I mean physical custody. The child's been going back and forth, so that's not an issue.
All right, very good. I don't have any issue with that being signed ex parte off the record. With that, we don't need a further hearing next week. I do want to make sure, though, that we proceed effectively. So as far as a review, Ms. Farr, do you have a recommendation?
I do. So once he files the regular petition, then a hearing will be set to be heard on that, which is usually 2 or 3 weeks out. So that'll automatically trigger from the clerk's office.
I want to set a hearing, though. I don't want to just have a immediate order without any sort of review. We would set it by based on the immediate order that's being signed. Okay.
And we would need a hearing to enter the emergency order once mom is served.
Yes, so I still do need it. So I think that probably having a hearing next week is still reasonable. So I'm still just going to put it on next week, but you can submit the order in advance of that hearing so that the transfer of the child can be effectuated.
Okay.
Or completed. And then we'll just sort of start reviewing where we are as far as service on the parents under Mr. Peters' petition.
And then, Your Honor, were you going to prepare the order appointing me, or did you want me to do that and email it to your JA?
Oh, if you would prepare that and send it to the JA, that would be greatly appreciated.
Okay, thank you.
Are we sending both case numbers over or just Mr. Peters to next week? I'm going to set both case numbers over next week, just so that the court reviews, make sure that that order got entered that dismisses Ms. Cutbirth's petition. And I just want to have tracking on that.
For the final or for the regular minor guardianship, not the temporary one, does Mr. Peters have to have me served, or can he just serve the mom?
You can just, Ms. Farr can help you with that piece of things.
Oh, okay.
Yeah.
Okay.
Right,
thank you.
Anything further from you, Ms. Farr, on this matter?
I think that's it, Your Honor. I think you covered everything.
All right, very good. Anything further from you, Mr. Peters?
No, Your Honor.
All right, anything further from you, Ms. Cutbirth?
No, thank you.
All right, appreciate everyone's time. Work on sort of those cleanup matters so we can get everything squared away, and we'll see you back here next week for Mr. Ignastu's motion. I did have an opportunity, just so everyone knows, I did have an opportunity to read through the vast majority of the file. And I read both in the 13308 file as well as the 00078 file. So I read both files to have a complete understanding of where the case is and sort of where the case has been. It's my understanding the cases are now consolidated by court order, but I just want to make sure that there was nothing missed. Right. So with that, Mr. Ignastu, it's your motion.
Right, correct, Your Honor. It's my motion for visitation for my client, and you got my response to my reply to counsel's response.
I did. So I received a copy of bench copies, including a declaration of Jeremy Aldridge. I received your response, and there was a couple additional sealed materials that I reviewed, as well as declarations of your client, or a supplemental declaration of Mr. Fletcher.
Perfect. I just wanted to make sure you had everything. And so I guess my initial question is, my motion is before the court. Counsel has objected procedurally. Do you want to take up the procedural issue first, or do you want me to argue regarding visitation for my client?
I think the main issue is the procedural one, so you should address that.
Okay. Well, with regards to the procedural issue, and in response, we filed our response. Counsel is misstating where we're at in this case. Where we're at in this case is that my client would file a motion for intervention, but he doesn't need to. He's a party to this action. And intervention clearly indicates that it's done by motion. The facts would support him being an intervener because he had custody, he had placement of Serenity in his home at the time that the Aldridges started their guardianship action. He had to be a party. He was a necessary party because the court had to have jurisdiction over him to issue an order that he return or turn over Serenity to the Aldridges, which is what the court did. I think it's just clear. My client's a party to this action. He's a party. He was served, and he was ordered to turn the child over. His visitation rights, although the petitioners alleged in their petition that he had visitation rights and that he's an interested party, those were not decided. They have not been decided. There's no res judicata issues regarding his visitation rights. So procedurally, I think we're here appropriately. My client brought a motion in this action. This action, as between both my clients, Mr. Fletcher and Ms. Hedrick, as from their position, is identical to the Aldridges legally. This isn't a Troxel case where you have a biological parent who has greater rights, constitutional rights. This is two parties that are on equal footing. My client had placement of Serenity, and now the Aldridges have placement of Serenity, and as between them, they're on equal legal footing. And my clients requested some visitation rights, and we think it's important that those be granted to for the benefit of Serenity. We set forth the declaration of Tracy Hedrick from when we filed this motion, pointing out the very close, loving relationship she has. The response by counsel, she raises various issues with regards to you have to be a parent. In particular, they raised RCW 2611. That doesn't apply. It just doesn't apply. That's a statute that is basically in response to the Troxel decision, and it indicates that a relative, and they're saying my client. So basically, it's a straw man argument. They say you have to bring this under 2611. We can't. We couldn't. That statute is 2018. There's only been one case on it. I take a look at it. It was a grandmother who was seeking visitation rights with her granddaughter from her daughter, and the court said, you don't have standing, and you're going to. And when they talked about standing, it was you have to prove certain elements in order to go forward under that, and it's against a biological parent. And I believe they awarded attorney's fees in that one case, but this is not that case. That's a straw man argument, Your Honor. My clients are parties to this action. They had placement. There was an indication that in the petition that visitation, other parties who have potential visitation rights, they were listed as that. And we're here to seek those. They haven't been decided yet. And the petitioner's objections are just not applicable. They've claimed res judicata. That's not applicable. RCW 2611 doesn't apply. A modification. We're not seeking a modification of the guardianship. It's I believe my client's motion is appropriate before the court. It concerns Serenity, which the court has jurisdiction over. It concerns two parties on equal footing, and what we should do going forward. And so I would ask the court to not grant the requested relief in the petitioner's response, and to grant some kind of residential time. I'm not sure if you want me to switch gears and go into the visitation, or if you want to hear from counsel regarding just this procedural issue first.
Well, we're going to address the procedural issue first. So when you agree your clients were present at the April 18th hearing, where the court discussed and made decisions regarding the child's placement as well as guardianship?
Yeah, my clients were present.
Didn't they have an opportunity to be heard about visitation at that time?
That was not the issue before the court at that time. So the parents had signed documents switching, basically making their recommendation as to who they would want placement, where they would want Serenity placed, and the court accepted those under the provision that allows that in the statute. RCW 11-130, and I'm not sure of the specific site. I had that regarding parents being able to direct where a child who has guardianship. That was the only issue before the court at that hearing.
But wasn't that the time to bring up visitation requests when the court was making placement decisions?
Well, it could have been, but I don't think it's mandatory. It wasn't. My client's rights were not discussed during that hearing.
Well, didn't the court take the child and dismiss your client's action and place the child with other people? It seems like your client's rights were discussed at that point, and the court made orders at that point.
My client's action wasn't dismissed. It was later consolidated into their action. That only happened a week ago or so. Well, late June, a couple weeks ago. I think I have that.
Says the emergency minor guardianship is dismissed, and this cause number shall be consolidated with the 13308. So that
Right.
looks like a dismissal.
Yeah, I understand, Your Honor, hanging your hat on the first part of the sentence, and my position is the second part of it. It was dismissed and consolidated into the Aldridge's action.
Didn't subsequently to the court placing the child with the Aldriches, your clients file a motion for reconsideration, which was heard and denied by the court?
Correct, and that was in their a emergency guardianship petition on an emergency basis, which is, yeah.
Isn't the motion that you filed, you requested to be co-guardians?
That's alternate relief, correct.
Hasn't the court already ruled on guardianship at this point?
Yeah, they have, and RCW 11-130-050 indicates that the court at any time may appoint co-guardians. That's what it says.
Isn't your request essentially to modify the child's current placement?
No.
How so? Aren't you asking for visitation?
Yes, we're asking for visitation. My client's parties to this action, that it has not been heard before the court. And so that we're asking that it be heard.
Do your clients qualify to be guardians of the child? Like, could they even qualify? Let's say this child is just in the wind. Could they even qualify to be guardians?
I believe so. They have raised all sorts of criminal backgrounds on my client, Brian Fletcher. And as we pointed out, they were dismissed, and he has filed basically what's equal to the watch report here, the Oregon reports regarding his background for both he and Tracy Hedrick. They have no criminal background. But again, Your Honor, that's an alternate request. That's a request under RCW 11-130-050. Where the court has authority at any time to appoint a co-guardian, we think, or a co-guardian. And my client's primary request to the court is to be able to see this child, see Serenity. They have a close, loving, bonded relationship, and as she does with them, they're her grandparents, even though legally my client is not a parent or grandparent, but biologically he is, and the mother has maintained a relationship with her biological father and family, and my clients are on equal footing with the Aldridges. This is not an RCW 2611 case. And we think it's important that the court consider, there's been references that this issue would be resolved by agreement, but the Aldridges won't talk to my client.
Are they required to agree?
No, absolutely not. That's why we bring motions.
All right. Ms. Winkles, I get to give you an opportunity to argue. I'll tell you a couple of things that don't matter to me. In this matter, Mr. Fletcher and Mr. Ignacio's clients, that I would argue they're fictive kin. They're not biological, or I should say they are biological, but legally not related. I think that doesn't preclude people from being interested parties or parties in and of themselves in these types of actions. So those arguments, I understand where they were raised, but they also don't sway me. Just sort of, I don't think that they really rate just based on how the law plays out in this area. So with that sort of caveat, I'll let you go ahead and make your argument.
So the only reason I brought those up is if you are a non-family member, you cannot have been convicted at any time of a number of things, including assault, neglect, or crimes of moral turpitude. And the fact is while these were DOC vacated, these 21 felonies, they were not dismissed. They went to trial. He was convicted. And so in order to have those felonies overcome, he has to be a family member. And he's not by law. That's the only reason I brought that up. But in reality, we don't even get to that point. There is a full minor guardianship order in place. That minor guardianship puts my client in a much better position. It puts my client in the position of a parent. It is essentially saying to the world that this is the person acting in the stead of the parent. That means he has the right to determine visitation, except for anybody who has a constitutional right to their children, which is why the court continues to have a fluid relationship with the parents, and visitation increases. But any third party, just as a parent would, they can deny. Now, the only way out of that is to use RCW 2611, which essentially says you can petition, pay a bunch of attorney fees, and try. Mr. Anagnostou knows that his client doesn't want to pay attorney fees. It's likely that it's going to lose. Our county hasn't done them. There haven't been many done because you have to pay all these attorney fees. So what's happened here? We've had a final order entered. They had their petition. They sought guardianship as well. Mr. Anagnostou's clients, they lost. The child was placed with my clients. Visitation was determined at that point. It was determined for the parent to have a right to the child, and my client was put in the other position. Mr. Fletcher may be a quote unquote interested party, but he has no legal right to this child. And that was decided because he attempted to have that. And it was decided, and he tried to get a reconsideration. And it wasn't just a reconsideration on the emergency. You'll notice that the minor guardianship order came, and he did the 10 days of that order. He reconsidered the minor guardianship order. Now, Mr. Anagnostou brings up 11-130.050 as his basis here, that you can appoint a co-guardian at any time. He doesn't read the rest of that. A co-guardian can be appointed to serve immediately when and if one of the events occurs or the co-guardian complies with, and it gives this other statute, 040, which is not at issue here. The event that's occurring is the incapacity of the guardian, is the death of the guardian or soon to be death of the guardian. The events that we're talking about here are significant, and they mean that the person is either going into surgery, long-term surgery. It mentions a bunch of these different reasons under the standby guardianship as well. These events are significant. That hasn't occurred. This order was entered in April. There's been no change in circumstances. According to Washington practice, which is not binding, but it's just a little influential here, it is very clear that it states that when you have a custody order, and that's what a minor guardianship is really custody order. When you have that, in order to make a significant change in that, there has to be a significant change to the child or the people with the child. And Washington practice quotes that as being appropriate in these cases as well. And it really is. There's no reason. It's been April. They've had another bite at this apple already. They tried to get the emergency. They didn't get it. Nothing has changed since April. My clients, they're trying to pull off this other thing. These people adopted Mr. Fletcher's children a long time ago because he was arrested for severe neglect. He lost 4 of his kids. And these kids, one of them had this child is a grandchild. But it's not Mr. Fletcher's grandchild. It's my client's grandchild who raised Mr. Fletcher's kids as his own, his own birth certificate and the whole lot. The fact is, we've already been here. Procedurally, it's absolutely incorrect. And furthermore, it is a modification, which requires a petition and personal service. You don't just get to choose to do a motion because it's easier. You can't just suddenly call yourself an intervener when the court case is closed because there's been a final order in place. They had the ability to do a motion to intervene when the case was active. The case has a final order in it. That whole question of who's guardian, that was decided in April. I would ask for CR 11 sanctions. Frankly, this is just a third bite at the apple now. It's procedurally absolutely incorrect. Service hasn't been made appropriate. My clients have had to pay me to come and argue this. And there is another act. It's called RCW 26 that allows them to try to get visitation if they so desire. They will need to pay my clients legal fees for that up front. That's the way we do it. If they can't afford that, unfortunately, they can talk to Mr. Aldrich and try to be friendly and become friends with him, because right now the court has determined he is the best person to make the decisions for the child. That's what they determined in the minor guardianship order. And just like a parent, you get to choose who you want the child to be around. I'd ask that Your Honor deny the motion with prejudice and give my client attorney fees for having to be here. Thank you.
All right, Mr. Anagnostou, any response?
Yes, Your Honor. The comment that my client is seeking a significant change is not supported by law in the state of Washington. I cited a case regarding that. Now, the case is a dependency case. And in the dependency case, on page 4 of my brief, at the top, I've quoted the case. MS argues JR's permissive intervention substantially alters the status quo because he's not a parent. And then it goes on. And the court ultimately, this is their ruling in that case, granting JR party status as a permissive intervener to move to de facto parentage does not substantially alter the status quo because JR was already, and then it goes on for there. So my client's request for visitation with Serenity does not alter the status quo that the Aldridges are the guardians. My clients are parties to this action. They would have brought a motion to intervene, but they didn't need to. We brought the motion to establish these visitation rights. They haven't been determined before. They bring up criminal records of my client. It's interesting they don't bring in Mrs. Aldridge, who has apparently some criminal history background, and she surprisingly isn't here today. We point that out. They have somebody living in their household in addition to her that potentially has some criminal history going on. But, my client's stuff that he took care of 20 years ago and is all vacated or dismissed, they're hanging their hat on that. And, the guardian ad litem indicated that there's some kind of potentially drug use by my clients. So they did hair follicle tests and submitted that to the court. They're totally open. This is the point. We have a child who had a close, loving relationship with and considered, although not legally, considered them grandparents. We think it's important in this guardianship that relationship be maintained, that she's being harmed by not being allowed to see. Setting up a straw man, you should have done this motion or brought this petition that is ultimately going to lose and not supported by the law is not what we're here to do. We want to benefit the child by this motion, and that's what our request is to do. And we think it's appropriate, and it hasn't been considered by the court up until now.
Ms. Farr, I see you there. Would you like to provide input?
The only thing I would add, Your Honor, is that the findings that were entered in April dismissed the Fletcher's case under Section 15. So I don't really understand why the cases were consolidated after that, because that terminated that linked emergency.
I really take
case.
issue with guardian ad litem giving legal opinions, not previously.
I asked for it.
Okay, well, I'm just raising my objection.
All right, fair enough.
So that's one issue. The second issue is when the mom signed the consent, she does not want the Fletchers to have any contact with her child. She still doesn't. I just talked with her a couple days ago. So both the guardian who is appointed and mom do not want the Fletchers involved in that child's life.
All right, give me just one moment.
The only other thing I would add, Your Honor, is something that I think is important for the court to know, and that is the only reason the Fletchers had the child in their possession was because they filed the emergency action ex parte, and it was granted an ex parte, and it was done under false pretenses. And so I just, that little less than 2 months that they had serenity probably shouldn't have happened. And so that's really the only connection they had with that child. According to the mother says that all of the assertions that they have been in Serenity's life is false, that she does not have a connection with them at all. So that's all I would say, just those three things to consider.
I appreciate everyone's arguments. Again, I did spend time reading this file, going through clerk's minutes, going through this file. They said that both of the court files and looking at them, it's very clear that the court looked at both of these folks as potential guardians. The guardian ad litem, Ms. Farr, looked at both homes. Even I think her report even references that. And so the idea, and the court chose very clearly that the only guardians it was appointing were the Aldriches. Subsequently, there was a motion for reconsideration and a denial of that. And now subsequent motion saying, no, appoint me co-guardian. That's not appropriate. The court made a ruling, and you can't just refile another motion and ask for another bite of the apple. That is what that is. The statement that you can do it at any time, but not when the court's already made a ruling. And in this case, the court clearly had. And so I do find that the court very clearly made a ruling on that. That ruling was not, there was no equivocation on it. Everyone was aware of it. When you file a motion for reconsideration, it's not because you don't understand what happened. And so this is trying to relitigate that issue. So I think the first issue really is the raising of the co-guardian. I'm denying that. That's not appropriate. The court's already ruled. And I'll address sort of subsequent issues on that. On the issue of visitation. So there is a request for visitation. Again, I did read the clerk's minutes. Both of Mr. Anagnostu's clients were present at the time of the hearing when the court was making its ruling about visitation. There's the subsequent order appointing minor guardian goes through in detail what mom and dad's visitation is going to look like. If there was going to be visitation, that was the time. The idea that we complete a case, we close a case and we move on, and at any point, an interested person can just come along and say, well, I didn't speak up, or I didn't, or I did, and the court ruled against me. And so I'm going to subsequently obtain a lawyer and then file a motion, isn't appropriate. Second, there's a limit to how many slices of time a child has. In this case, the child has her primary caregivers, which are the Aldriches. It sounds like there's visits happening with mom. At some point, there'll be visits happening with the father. The idea that we can just apportion time to everyone, I think, isn't appropriate. There has to be a limit. And that's the purpose of a guardianship, is that those people, other than the parents who have very clear constitutional rights, that we're not going to sort of slice and dice a child's time between a whole host of other people. That's really the job of the guardians. And hopefully, eventually, the job of the parents, if the children are ultimately returned to the parents, to make those determinations and those calls. And so at this point, I'm denying. I don't think it's appropriate. I don't think the motion's appropriate. I did read it in its entirety. I understand people are bonded. I understand that people have relationships. The purpose of the guardian is to make the best determinations for the child. So I'm denying any requests there. I'm not making any finding on whether or not, I think the court already made its ruling, but even if subsequently the court says it didn't, I don't think it's appropriate. Again, we already have visitation to both parents to contend with. and the Aldriches. Three hands in the pot is enough. I think adding additional folks would only cause complication and then cause issue with the parents' constitutional rights. So where that takes us. So that takes us to a place where I've said the first motion, which was to be appointed co-guardian, was inappropriate. And I'm denying the request for visitation based on A, I think the court already ruled, and B, I don't think it's appropriate. So Ms. Winkles, with the understanding that I've sort of agree in the sense that the request for co-guardian was inappropriate, what's your request for fees regarding that issue?
My requests for fees regarding that are still obviously the baseless filing because of res judicata. My request for fees for just that part without the visitation, which is one of the reasons we did not file a response to the request for visitation, minus one filing of the text messages. My request is for $2,500, which is the amount of attorney fees. It's actually $2732.76. And I can file those, but I think $2,500 to take care of the text messages and any argument we may have made today on the visitation.
Okay. So with that, because I do find I am going to order fees of $2,500. I find that that's reasonable. I think that the Mr. Ignacio's clients, they were well aware that the court had made its rulings and pushed forward on that issue. I think that they were also aware, but I'm basing that essentially on the request for co-guardian when clearly that's not appropriate here. So, okay, that is my ruling. Anything further from you, Ms. Farr, on this matter?
No, Your Honor.
Anything further from you, Ms. Winkles?
Just that I'll be filing my affidavit of attorney fees that go along with that number.
Very good. Anything from you further, Mr. Ignacio?
No.
All right, very good. So with that, I don't have a set presentation date. And so if the parties can't agree on the form of the order, just reach out to the JAs. And you should be able to find and agree. We'll propose a couple dates and make sure something works for both of your schedules.
Thank you, Your Honor.
All right. Thank you both.